Good evening. Um, this is the special meeting of the Village Council, which is a hearing for the appeal to the governing body of an amended Site Development Plan, SCP 2603. This is an appeal of the amendment to the Site Development Plan on April 15th, 2026 to the applicant Robert Hobbs. The approval granted the applicant the ability to place 2 shipping containers in an outdoor gazebo on the property. This 1.32 acre parcel is Zone C, Neighborhood Commercial. The appellants are John Campbell, Kathy Campbell, Deborah De La Torre, Mariana Miera, Rudy Miera, Kendall Ritter, and Stephen Ritter. The appellee is the original applicant, Robert Hobbs. My name is Fred Hashimoto. I am the mayor of Corrales. I'd like to interject something. This is a rather scripted hearing, but I inadvertently listened to or looked at some of the video of the hearing before the P&Z Council, and I didn't talk to the appellant or talk to any of the opposing people. I read the minutes of that meeting, which were published last week in the council packet. So the minutes of that meeting were in the packet. They basically reflected the meeting as I saw it on the part of it that I saw on video for the P&Z. If people want to have me recuse myself, I will entertain that. I don't think I'm biased by what I saw in the video, but I will leave it up to you all whether you think I should recuse myself. Council, Mr. Hobbs.
I have no issue.
Mayor, point of order. I think we need to have call order in the call of the council.
Okay. Yeah. Point of order. Okay. Anyway, I am functioning as presiding officer of this hearing. The hearing today is a quasi-judicial hearing, and the decisions will be made by members of the governing body. I'm going to conduct a roll call for the record. Councilor Miera.
Here.
Councilor Woolman.
Here.
Councilor Knight.
Here.
Councilor Burkett.
Here.
Councilor Murray.
Here.
Okay, now going back to my previous statement, as I said, I don't think viewing that portion of the video was reflected in the minutes that everybody read, the public read last week, prejudiced me one way or another. If somebody thinks I should recuse myself, I will.
No.
Nope.
I just wonder why you did that.
I was curious. I heard that somebody wanted to read something into the minutes and wasn't allowed to. And to me, as a presiding officer of hearings or meetings, I usually let them do it. I was just curious how that happened. That's why I looked at it. It was just a curiosity. It probably had nothing to do with the function or the substance, but it was just how a meeting was run. And I was surprised that a presiding officer would not allow someone to read into the minutes something that person wanted.
You know what? I need to tell everybody this. When I first got on P&Z, we were talking about an address someplace in Corrales. I thought, I'll go down there and look at that. They're like, you can't do that.
Me too.
I was like, hey, I thought I was doing my due diligence by doing this. And they're like, because everybody has to have the same exact information when you're on P&Z. So me going to that property was like a big no-no. And again, that was my first time on P&Z. I didn't realize I couldn't do that. I thought I was doing my job, but
Right. And
I did the same thing.
I've always felt that, when you come to a quasi-judicial hearing like this, everybody has equal footing from minute one. But when I saw the minutes of the P&Z meeting were in the packet last week, I asked the attorney, I said, hey, everybody can read the minute prior to the meeting. should they be reading the minutes? But it's too late by that time. And the attorney said, well, they're out there and it's for the public to see. Yes, Councilor Burkett.
I mean, I guess this is further justification for why we chose not to put the videos on the website just 2 meetings ago. We had that conversation about we weren't going to put the P&Z meetings on the website because if somebody did watch them, that would create a problem for an appeal. And it only took a month for it to potentially make a problem.
Councilor Murray.
All right, so when I went through the packet, I found that there was information missing. And consequently, I would like to see an amended packet sent to us. So therefore, I'm going to make a motion that we postpone the appeal hearing, SDP 2603, to next Tuesday, June 9th, 2026 at 5 p.m. in council chambers. And this will allow the administration to submit an amended agenda packet containing the April 15th, 2026 Site Development Plan 2603 documents. The administration is to submit and post the amended packet with all relevant information, including reports, drawings, correspondence of SDP 2603 no later than June 3rd, 2026, 5 p.m.
Okay, we have a motion. Is there a second on that motion?
This is a quick point of order before we get into that. If I could have 5 minutes to verify that that meets notice requirements before, if a date certain is set, that we're complying with what we need to do for the appeal hearing notice requirements.
Sure.
Just take a short second.
Yeah.
Sometimes it gets turned off.
So,
She's just wanting to verify that we're going to meet state mandated notice requirements so that if he does suggest that we go to the 9th, that is ample time to publish the documents so the public has time to review them and we meet state regulations.
Can I ask a question?
yes, Councilor Knight.
Thank you, Mayor. What was missing?
Well, the stuff that we just received today, the correspondence, I read in the minutes that there was correspondence that was not in our packet. And yet,
I'm just asking.
well, I know, but I'm sorry, but I mean, there was missing information. Basically, we got 2 drawings. That was not the complete set of drawings from this SDP 2603 and April 15th. The missing correspondence, I had no idea what it was, but it was in the draft minutes that it was there in their packet, but they were not allowed to speak. So what correspondence was that? And then here it's showing up tonight, but the public hasn't had a chance to see it. So I don't think we have our ducks in order right now, because procedurally, if the public hasn't seen these documents, I mean, if this bounces up to district court based on whatever we do tonight, the village could lose in the court fight because we did not have all the information. All I'm asking for is the entire site development plan 2603 that was presented on April 15th to the Planning and Zoning Commission as an amended packet. We're just missing things that are routed, were never there. So that's the only thing I'm asking for. That's why I want to delay, is to allow the administration send us an amended packet that can post it on the website. The public can review it and have time to make comments when they come back.
Okay, and so then the information that you were telling me is all this information that's positive, then that would be submitted as well, right?
Yeah. I mean, all the comments and correspondence, they were not there.
Was this not submitted in the, excuse me, was this not submitted in the original?
It was not.
That's why I'm asking for a postponement.
Mr. Mayor,
Yes, Councilor Mira.
I'll second that motion.
Corey.
Mayor, members of council, the only concern I have is that when it pertains to an appeal of a decision, the appellant has 20 days to file the appeal. They met that deadline. Then council has 60 days to make a determination. And I am fearful that complying with legal notice requirements, which is 30 days. So if we postpone today, we need 30 days to be able to renotice the hearing properly. And that's going to put us outside of our required time to decide the appeal.
We can hold a special meeting.
But
There's
not
there's not enough time.
right. The deadline from the date that the appeal was filed to the 30 days that we need to make a decision will have told by the time we receive the 30 days of legal notice and postpone the hearing.
So we couldn't postpone to next week is what she's saying. It would have to go out later than that.
Well, I've got a feeling that we're putting ourselves on shaky ground right now because we did not receive the information. The public has not had a chance to look at it. We just got it tonight. I'm really concerned, and we'll have to let the chips fall where they do if that's the case, because if it gets kicked up, depending on what this council decides tonight, if it gets kicked up to district court, we're going to put ourselves in a real bind. And that's my big concern. I don't want to see this happen again. I want the entire, at times there is appeal. I want the full packet. I don't want just portions of it. I want the full packet from the meeting. So let's not do this again if we can.
I'm sorry, I need to be very clear.
Can you come up to the microphone?
Well, I just need to be very, very clear. What was missing in the April 15th meeting?
The comments that were attached to the planning and zoning,
So we didn't see anything from the April 15th meeting other than the minutes. We didn't see any of the public emails that were submitted for that meeting.
So we sent out a packet to our council members on Friday.
yes.
And in that, the documents that are printed here that Mandy handed out, those weren't included in the packet that was sent to the council
Yes.
on Friday. So we were going to ask that these be added to the record tonight as part of the official record. So, and then we did make copies for everybody. I don't
I
know if
understand
you
that.
want to take a few minutes to
It's
to
not the same
review, but
as the entire public having access to these documents.
And Mayor, members of council, just for a point of clarification. So the entire public did have access to the entire record, and I understand that council is sort of uniquely disadvantaged that they don't have the same information, but all of the information as it pertains to the April 15th P and Z meeting is published, is available on the website under that date. And so I understand it's not sort of in the place where it would be ideal for the sake of having a clear and concise.
I
record.
disagree, council, because one, the packet that we get is what the public thought they were getting on the website. Regardless, now, if I have to go chase down a site development plan from a previous meeting, that is not public notice as far as I'm concerned. So we need that entire packet the next time. I'm going to have to, I will withdraw my motion. If that's the case, if we fall outside 30 days, I'll withdraw my motion, but I do not want to see this again because you put the village in a bad situation, Counselor.
Understood.
And it's not good. I'm not ready to pay out something that the residents are going to really have the heartburn over. So let's not do this anymore. I mean, let's make sure the council and the public has access to the documents under the posting that it is. They don't let them go chase it down. That's not right.
Understood, Mayor and members of council, and to be, it may be worth a brief recess to allow the council to review the documents since it was just provided to you guys. If you feel it's worthwhile, if it is something that you want to discuss or read into the record for the sake of having all of the information on the record, that also might be an appropriate strategy just to ensure that the record is clear with all of that information. But I will leave that in the hands of council.
Can I ask
Councilor
a quick
Burkett, then Councilor Mira.
Thank you, Mayor. My question is, reading through these documents, it looks like there's only two of them that talk about the containers or the gazebos, which are what we're addressing. It's one from Mr. Stephen Ritter, and then one signed by a group of neighbors towards the very end. The other documents that do not specifically address shipping containers and gazebos, is there any harm in not having those in because they're not part of what's being addressed tonight? The other two, I think, I agree 100% with Councilor Murray. They should have been in there. But those are the two. If we are going to take a recess and read them, those are the two that seem pertinent to what we're discussing tonight.
Councilor Mira.
On that point, then, we have them, but
we made
Yeah.
copies for them.
we'd have to maybe copies
Yeah.
to all of them and give them time for reading it while you're reading it as well.
Yeah, we did make, I believe Mandy made 20 copies in total, so it should be enough for each one of the appellants and then the appellee as well, and then council.
So what is your pleasure, Council?
Take a recess so you can take a look at it.
Okay.
So we can give it to the appellants over here, but the appellants, I'm sorry, so they can get the same information we have. And then they can address it when they come and speak about it as well.
So you like a 5 minute?
Be new information, they're allowed to bring it up.
10 minutes?
We have a 10-minute recess so everybody can review the documents that we just got tonight.
Okay, so there's a motion and
Second.
a second. Any discussion by council? All in favor, say aye.
Aye.
Motion carries. Okay, we have a 10-minute recess for people to read the documents.
And Mandy, you can go ahead and pause the recording while we take a short break.
Okay. Now I'm going to ask the appellants to please identify themselves. Would you please come up to the microphone and state your name and address, please?
Mayor, do we need legal counsel in the room before we proceed, or are we? Okay.
You go.
Uh,
I think she's phoning a friend.
And ask a question.
I think she had a procedural question, so we might want to wait for her for just another minute.
We missed you, Corey. Yeah.
Okay.
Are we good?
We
Well,
have
the-
points of order.
Okay.
All
If
right.
anyone's interested.
Yeah, yes, I understand. I forget that I have to write up on it.
Yeah.
So a point of order is that I was made aware that a site development plan is a thing that requires legal notice that generally also requires certified letters go out. Certified letters were mailed out for the original application and therefore the zoning hearing, etc. However, the certified letters did not go out for the notice of the appeal. That puts us in a procedural rock and hard place. Because as discussed prior, we cannot reschedule the appeal. Or the appellants lose their right to appeal, which I feel that for the sake of due process, we do not want to do. So my proposition, and this would need to be stipulated to by both parties, is to agree that you received notice sufficient to be here today and to waive the legal notice requirement for today's hearing. I agree that you did not receive the certified letters and proceed anyway. And if both parties agree to that, then we can proceed. The alternative is to lose the right to appeal.
We were told there were 19 letters going out.
Understood.
And there are one. Can I ask a question?
Yeah, if you have a question, come up to the microphone, please.
My question is this: if a letter was sent out, would it have mentioned that we were going to be discussing something more than containers? Would it be that we're going to discuss later hours in a different type of restaurant and this sort of thing?
No, the only thing that this appeal is discussing is what was in the application for the site development plan, which is the gazebos and the shipping containers. That's all that can be considered by council tonight.
Point of order, please.
Councilor Murray.
I disagree because there are sufficient deficiencies in the site development plan that were pointed out in the minutes that were not discussed. And I feel that that is a pertinent point to this hearing.
And Mayor and members of council, and that's a point well taken. And that's sort of the reason that I'm raising these procedural questions now so that we can proceed with the hearing. I just need all parties to understand what did not occur and should have occurred, and that I want on the record an understanding from both parties or a stipulation to proceed with the hearing, knowing that that certified mailing for this appeal was not able to be sent out.
Could all people involved in this hearing agree to postpone it for a week?
Mayor, members of council, so that's the difficulty, is that there is not an ability to waive. Perhaps.
I mean, if council,
That would be at the, I mean, that would be at the will of the council and truthfully at the, between the appellant and the appellees as to what they would agree to, with the caveat that we need to be very, very careful that we leave sufficient time that we are not going beyond the 60 days. The 60 days is a non-waivable requirement. And so that's what I don't want. I'm very cognizant of treading over. I do not want the appellants to lose their right to the appeal by delaying these proceedings. And so that's why
Right.
I propose an agreement here and now if we can get one.
there were some procedural things that had nothing to do with the appellant or appellee. And that's why we're in this bind.
Exactly.
And so
And
could
that's,
the village take some responsibility and saying, okay, maybe things weren't done optimally. Would all parties agree to a week's postponement so notice can be?
But that still wouldn't give us enough time to send certified letters.
So can I ask a question? When we say all parties agree, if there were 19 letters going out, in my mind, unless there's 19 people here to say that they're waiving their right to get that letter, we have a problem. Is that, I mean, if they're not physically here to say that I do accept that, we still didn't meet our burden, which is 100% our fault and really problematic. But I don't know what the solution is because we don't want to take away their right to appeal. We also don't want to hinder their ability to do business and have a timely appeal. Somebody's rights are going to get infringed upon tonight. And I'm not sure how we minimize that.
and mayor and members of council, the short version, and it's kind of a silly legal term, but it's substantial compliance, which is that we did post notification on the website. People do know to check the website for the minutes for the agenda packets. We do post publicly in public places whenever these hearings do take place. So the lack of a certified letter is not a technical deprivation of due process, right? Somebody who was interested in this had other means to obtain information about it. That said, it is a defect worth noting on the record to be able to ensure that the parties who would be impacted, i.e. the concerned neighbors who may not have all of their neighbors present, or the business owner who may not have all of the businesses in support of him here present at this hearing. And so it's understanding that both of those parties may have been impacted by that lack of notice to those people who are in the proximity of the building. And so, yes, there is a defect. Is it a substantial defect? Arguably, it prejudices both parties equally. And that's why I would need both parties to be able to state on the
So-
record whether or not they were okay with that.
In your mind, which
Awesome.
one is more important to adhere to, the timing or the letter not going out? I mean, which one is more consequential to ignore?
Mayor, members of council, it's the 60-day deadline to be able to make a determination. That is a non-waivable requirement, and that does lose an actual right to an appeal, and that makes me very nervous.
Okay.
If this
So we
went
have to
before-
do today or they can't appeal.
If this went before district court, what would a judge say? And the appellant say, hey, we weren't given notice. The packets weren't adequate. I mean, the village didn't do its due process, perhaps. What would a judge say? Oh, well, tough. Or
Well, and Mayor, I hate to opine because I am not a judge. However, I will anyway, for the sake of this discussion, which is that one of the things that is most important and is sort of always at the forefront of my mind whenever we're having hearings, particularly I do a lot of the quasi-judicials for the Planning and Zoning Commission, is to ensure that the affected parties are present. So the people who are concerned with this matter received enough notification to be here. Whether or not it was strictly compliant is not necessarily a factor. And that's why I said it's a doctrine of substantial compliance. Were people notified and are people here and able to participate meaningfully in this process? And if the answer to that is yes, then that's looked on much more favorably than if we simply did nothing, had no posting requirements, said we were going to send out letters and that was our only form of notice and also failed to do so. That would be a much more consequential problem to be looking at.
what is council's inkling on this? What would you like to do?
My only concern, Mr. Mayor, is just this first page, just the public comment had these people felt that the public comment was taken into consideration and now we're doing it yet again. We're gonna reopen this discussion for public comment, if I'm not mistaken. So maybe they didn't know that it was gonna be on these people that did this part. Are we taking away their ability to come say, had I known that we're gonna have a second go round at it, I would have showed up.
Correct me if I'm wrong, though. There's no public comment tonight. Only the appellants can speak.
15 minutes.
Yep.
And,
Yeah.
So we just have to
says
make sure
15
the
minutes.
appellants are here and we're notified and are here. That would be the bare minimum of compliance, is that the people who filed the appeal and the people who are being appealed are physically in the room and we're all notified appropriately to be here.
And it does look to me as though the people that did express concerns are members of the appealing body. So the people that said, you know, I have a problem with this, that's in this public comment, I believe are all here tonight. It looked like a lot of these public comments were in support of Mr. Hobbs.
So do you all think we should just, Councilor Knight, I'm sorry.
Thank you, Mayor. Let me put this in layman's terms and make sure I know what you said. The letters were sent out originally. There hasn't been any letters since, but it's been published in different places, like we usually publish information to let people know that there's meetings.
Yeah.
So that's where we're covered.
Yeah, it was posted in all 6 places that's in our Open Meetings Act and on the website. Yeah. Yeah, and the applicants that all signed the original letter saying that they were filing the appeal, they were all notified as well. So,
Okay.
and I think, you know, to answer your question about district court, they may just remand it back to the council and ask us to hear it again. And, you know,
Yeah.
So,
Okay.
yeah, I believe Corey's suggestion of, you know, if these people took time out of their evening to be here tonight, Mr. Hobbs is here tonight. If we can go ahead and hear everything, as long as they're, you know, the appealing parties are amenable to this, that may be the best situation going forward.
Is there a spokesperson for the appealing body?
Mayor, I suggest we give the folks 5 minutes to discuss this.
Would you like 5 minutes to discuss it? Okay.
No,
Move forward.
yes, and go ahead and proceed tonight. Yeah. Okay. Okay.
That's okay.
Yeah. Okay, so yeah, and for the record, the recording, they said that there were 2 people that did post public comment that had concerns that are not here tonight. Let's see.
Go ahead and discuss it, or?
Say Mandy.
We are a well-oiled machine.
Yes, we are.
Holy. As my son would say.
Right.
So the people that were the didn't get it.
Yeah.
Yes, the refunds are also supposed to remain the lobby. I don't think we generated a like they never saw it, the sales were like.
Right.
The library. Yeah. Yeah, no, I know. Yeah.
Seriously.
Right, yeah, no, it's, so they're right, every December, we ratify our open meetings act resolution, we can say what places we're at, all the meetings. And those are.
Okay, so everybody knows.
They respond via email, but that's not the, they certified.
All right.
That is definitely.
Counselors.
So all the people, all the people you spent out the.
I would suggest we
to
don't talk
responded.
about this right now. Because we are. Because we are under.
No, I think that's one step.
Everything has to be.
Oh, yeah, but that's the number of like 100, 300 feet or something Yeah, but I think that that's important to note that you sent emails and they all responded. So while it's not a certified letter.
Yep, yep. My understanding, that's really that has like perfect. So even if other people showed up, there's yeah, so it's on site, it's fine. We've had, notify, notify Friday, we
Yeah.
now,
I think-
not, it was like not, I all backfire, money. It's like.
I think. I go one step below the certified letter. He sent emails, they responded. I think it's fine. Yeah, yeah, yeah.
Then we're.
What's your pleasure, Rudy?
Do you want to come
Why
up?
don't you come to the microphone and? Are we
Rudy
recording?
Jamietta from 116 East Meadowlark. I'm one of the, is this on?
Yeah.
Okay.
Yeah.
And what I would like to say is that in the spirit of good faith, of truly being good neighbors, we are willing to waive our right. That's how far we will go, okay? We've always been straight up with you. We've always been honest, and we're not going to stop now, okay? So, yes. We'll do
Thank
that.
you.
For the good, for the common good. That's what we're all here about.
And for the record, can I just get you to say that you're willing to waive the right to the certified mail?
Yeah, in fact, when I get to talk, I will address that, okay? Should I even start talking now then?
Well,
I just need on the record that both parties are okay with the lack of certified mail so that we can proceed with the hearing.
He's-
Could you do it into the mic?
Yes.
To say that I'm fine with the lack of certified letters. I didn't even know I was supposed to get one, to be quite honest with you. So
And thank you.
emails like everything
Yeah,
else.
thank you. And on behalf of the administration, I apologize to everybody. We are human, mistakes happen. And yeah, I'm sorry that it happened with this hearing, and we will do better. So. Yes, yes, I was already thinking that. So yeah.
oh,
Yeah.
moving right along.
Mayor.
Yes.
If I
Mr.
might,
Woolman?
I just I'd like to point out that apparently, according to our clerk, every one of the appellants received an email and responded to that email. So while it's not, as you say, I think that meets a standard of substantial compliance.
I disagree, Mr. Waldman. An email is not an official mailing.
No, it's not. No, it's
So,
not.
but I will waive that and forego it, so we can continue with the meeting.
Okay. Would all the appellants, people appealing this, please identify him or herself? The microphone, please. Say your name and address.
One at a time.
One at a
Yeah.
time.
Rudy Jamietta, 116 East Meadowlark.
Sweet.
Deborah De La Torre, 28 East Meadowlark Lane.
Marianne Mieta, 116 East Meadowlark Lane.
Kathy Campbell, 80 East Meadowlark.
John Campbell, 80 East Meadowlark.
Okay. Now, may we have the appellee, Mr. Hobbs? Identify yourself, please.
Robert Hobbs, 222 Andrews Lane, Corellis.
Thank you. The scope of this appeal will be limited to whether the council will uphold the decision of Planning and Zoning Department to grant the amended Site Development Plan STP 2603. This appeal will not consider the prior decision to uphold the granting of the original 2023 Site Development Plan. If people go outside of that scope, I will call you on it and I will say that it is irrelevant. That goes for the parties as well as counselors, unless it is really related to the appeal. We are recording this meeting tonight so that a complete, clear record can be created of everything being said. However, please remember that we cannot create an accurate record with people talking over one another. So I am going to be strict about people talking over one another. If people start to talk over one another, I will stop them so that we can get a clear record. I would also remind all parties to please speak into the microphones so that their comments will be picked up on the recording. The council will have the opportunity to ask questions. Council, if you have any questions, please make sure you say mayor so that I can be sure that I see you, recognize you, and let you speak. Again, that is for the record, and so that we get those questions and answers down. The questions should be focused on clarifying the record or the argument given and should not include new information or evidence being offered by a counselor through asking the question. I'm also going to assume that everyone's demeanor is going to be appropriate and there will not be any badgering or argumentation of witnesses. I will call people on that. Hearing on the record. Evidence in this hearing is made up of everything in the record from the Planning and Zoning Commission hearing. New evidence or testimony is not allowed unless it is allowed by the governing body to be introduced for the first time tonight. The decision is on the record of the hearing below, and if an exception is granted by the governing body for good cause, that's new evidence. Evidence that includes testimony and exhibits. If either party has exhibits to present that are not in the packet, please present them to the village clerk for distribution to the governing body or for display on the video screen after it is determined admissible by the governing body. Process. Before I give an outline of the specific process for this hearing, here's a general outline of how the hearing will run. First will be testimony from the appellant, people appealing, as to why the decision of Planning and Zoning Commission should be reversed. Second will be the presentation by the appellee. Each party's time will be limited to 15 minutes. A party may request more time if the matter being heard is extremely complicated, and upon their request, the governing body agrees. The appellant and appellee may present argument or call witnesses if allowed by the governing body, and any new witnesses will be sworn in by the village clerk. Both parties can rely on the record of exhibits and witnesses from the Planning and Zoning Commission meeting where the amended site development plan was heard. If there are exhibits or visual argument, those again should be given to Mandy to put on the screen. You will need to explain what the exhibit is. Before making a final decision, counselors or I may have questions of the witnesses limited to clarifying the evidence, the parties' arguments, or the decision of the Planning and Zoning Commission. No independent evidence should be offered by the counselors or me, and I will remind us if necessary. After questions, I will close the hearing and the governing body will deliberate. The village council may make a determination in open session or decide to deliberate in closed session as allowed by the Open Meetings Act. All decisions must be made in public. The governing body may grant the appeal and deny granting the requested amendment to the site development plan, deny the appeal and uphold the amendment approval, or amend the decision of the Planning and Zoning Commission. Once a decision has been made, then there will be a direction to our attorney to prepare a written decision and findings of fact and conclusions of law supporting the governing body's decision based on the facts established in the record. The hearing date shall be set at that time for a vote on the form of decision as soon as practicable. After the approval of the final decision, the appeal will be concluded. Any questions? Councilor Murray.
Thank you, Mayor. So this is more of a point of order. So if the draft minutes contain issues that fall outside the 2 points that are being brought before the meeting tonight, is that allowable by the council to comment on?
Mayor and members of council, so yes, those items that were discussed below are going to be relevant to the consideration of this appeal. What I want to avoid is conflating a lot of those comments had to do more with grievances of the original site development plan, which has already been approved, appealed, and reaffirmed by council back in, I believe, 2023. So what I understand that, yes, a lot of comments are going to come up that they're not directly related to this.
Well,
but they are up for discussion
Right.
because
So
they do have a bearing on it.
one of my comments is, and before we get into this, the restaurant that's going to go in now is not the same as the delicatessen that was there. Therefore, under the rules for the Planning and Zoning Commission under 1845 and I think 1837, this is a use by review that the Planning and Zoning Commission should have had a resubmittal of this site development plan with all pertinent information there is. I'm just a little worried that they're not addressing deficiencies that are there right now. And even though it was approved back in 23, these deficiencies need to be addressed. And I'm just curious how we're going to do that if we're saying that we can't modify the existing site development plan from the original one.
Understood. Mayor and members of council, to be clear, one of the options the council does have is to alter the determination that was made by the Planning and Zoning Commission. If evidence is presented to you tonight that indicates that perhaps conditions need to be set on this plan or things like that, it is well within your purview to do that as well. And sort of as a side note, some things such as a violation of the dark skies ordinance, some violations of noise ordinances. Those are things that are better addressed through code enforcement and less so through this appeals process. So it's not that they're not important, it's that this is not the right avenue for those kinds of complaints because we have a different mechanism for those.
Okay.
The question is the amended site development plan specifically talks about a delicatessen. And this talks about a restaurant. I mean, that's what we hear now. Is a delicatessen and a restaurant, are they the same thing?
Mayor, members of council, to be perfectly candid, I would need to take a look at village code and how items are defined to be able to give you that answer, but I will, as this hearing progresses, weigh in on that for you.
I don't think it's clarified in village code, but I think restaurant is a use by review, and I don't think delicatessen is mentioned anywhere, but that's you can speak for your 15 minutes, Robert. Okay, this is open to council right now. There are questions, then the appellants have 15 minutes and you have 15 minutes. Any more council questions right now? Okay, we'll give the appellants, people appealing this, you have 15 minutes to present your case. You can divide it up into whatever segments you want, but the total is 15 minutes by procedure. Okay, you may start.
Corey, do we need to swear everybody in again?
If they were not sworn, yes, please.
Okay. So is the fact that they were sworn in at the P&Z hearing still technically good? Or do we need to swear them in again tonight?
I would prefer to get them sworn.
Okay, so Mandy,
I still prefer.
let's do them one at a time. So
Yes. Yes, I do. My name is Rudy J. Miera, and I'm at 116 East Meadowlark. And we have 15 minutes total. I'll just take my 3 minutes, okay? And the reason I'm here and the reason we appealed is because this whole process has been fraught with confusion, chaos, and a lack of sticking to procedures. Well, let me say, Honorable Mayor, thank you for your time. Melanie, honorable and respected councilors, you should not be put in the position that you are right now. And the reason for that is the reason for the original appeal and the reason for the appeal upon the appeal upon the appeal. Because what we have in the village of Corrales is not a review process, which is the main responsibility and duty of the commissioners and the commission. What we have in the village is basically approval process. You know, sometimes when things don't line up the way they're supposed to, or if somebody changes the land use, what happens is the administrator says, oh, well, we'll go ahead and we'll rewrite your site plan development, okay? Instead of the normal sequence of events is that you come before the commission, you propose your amendments, your changes, and then you are approved. And then you make the changes, okay? This is basically the argument I did before the commission, but it didn't matter. It still, you know, went through. And so essentially, my main beef is that we need to have a planning and zoning commission that follows what you all do. You've been put between a rock and a hard place because things have not gone according to protocols, procedures, and the guarding of everybody's, thank you, Zach, the guarding of everybody's rights, okay? And that's what this is all about, our rights, okay? And it can only happen if we are straightforward and honest and we follow procedures. That's why we've developed ordinances. That's why we expect ordinances to be followed. And that's why we are still a village, because to the extent that we do that. But we need to stop pretending that we have a review process, because we don't, you know. But don't get me wrong, I'm an optimist. You know, they say elections have consequences. I still believe that we will get to a point where we will have a review process, not an approval process. See, approval comes at the end of the review. It's only part of the review, okay? And so what I want to invite you all, everybody, to do at this moment is to do what I'm going to do. Think about what it would be like if we actually had an honest, consistent review process with integrity. Think about it, because that's what I'm going to do right now. I'm going to think about what that would be like. Set of commissioners that were answerable to the residents. Okay, I'm going to stop. I've probably reached my 3 minutes. Thank you.
Hello. Good evening, Mayor and council members. I'm Deborah De La Torre at 28 East Meadowlark, and I swear to tell the truth. Thank you for hearing our appeal of SDP 2603 regarding the Robert Hobbs property at 3650 Corrales Road. The approval of this site development plan amendment should be denied because the proposed use does not comply with the requirements of the Village Code Article 2, Section 1845, B2, specifically letters E, F, and G. In addition, and most importantly, the Planning and Zoning Commission could not make a fully informed decision because the public summary presented by staff stated that, quote, previously approved uses within the building itself, offices, retail, and small restaurant will remain as is, unquote. However, the actual application submitted by Robert Hobbs clearly states Old Bell's Deli to be Gale Road Pub, a pub with cooking, extended evening operations, alcohol service, and nighttime activity is not remaining as is. That is a substantial intensification of use with major impacts on the surrounding residents. There's a big change of hours till serving till 9, and then with staff cleanup, there will be people there till 10, and then with alcohol being served, along with alcohol, it just increases all of these impacts. The proposal also fails to comply with Village Code Article 2, Section 1845B 2F, general compatibility with existing adjacent properties. This property lacks direct access from Corrales Road, forcing all commercial traffic onto Meadowlark Lane, a residential street never intended to function as a commercial corridor. Increased restaurant traffic, food delivery, beverage trucks, customer congestion, nighttime activities are incompatible with the quiet residential and rural character of this neighborhood. The zoning is neighborhood commercial. Alcohol and extended hours are not neighborhood friendly. The proposal further fails to comply with the Village Code Article 2, Section 1845B 2G, the overall health and safety of the community. Increased commercial traffic creates additional safety concerns for pedestrians, equestrians, bicyclists, families, and residents who use the road easement on Hobbs side of Meadowlark Lane daily. We purchased our home in Corrales because of its peaceful rural character. We did not purchase homes next to a pub, a bar, or expanding commercial entertainment use. Would any of you want to see this project move next door to you? The residents were here first, and the Village Code exists to protect the compatibility, health, safety, and quality of life of established neighborhoods. The zoning is neighborhood commercial, not commercial neighborhood. It's neighborhood commercial. You are all invited to come to my home to see for yourselves. For these reasons, I respectfully request that the approval be denied. Thank you.
She did.
Sure.
My name is John Campbell. I live at 80 East Meadowlark Lane, Corrales, New Mexico. Excuse me. I do. Thank you, Mayor, and village councilors for listening to our appeal tonight. I appreciate your earlier discussions about circumstances that we were having problems with and confusion that we had about this whole process. This is kind of, as my favorite philosopher Yogi Berra would say, it's deja vu all over again. We've been up here, numerous times. I know the council's probably getting tired of seeing it, hearing this, but I know Robert Hobb is. And I can understand that. And I respect his entrepreneurial spirit. And he's I'm sure he's a good guy, and I'm sure he's gonna, very conscientious and responsible. But we just didn't want a pub in our area. Been used to a nice quiet residential lane, and with a lot of horse traffic, a lot of bicycle traffic, a lot of traffic, period. And we don't have, or I don't have any hopes here tonight of anything changing, of this approval being denied. I think the writing is pretty much on the wall, but I just want to reiterate a few points that Deborah made and that are, I think, important. And that is the applicant's site development permit filed with P&Z on March 4th, 25 included language to the effect that the restaurant approved as, quote, Old Bell's Deli would be Gale Pub Road. Other changes in addition to the change of the restaurant requested were to improvements on the property, such as the shipping containers, which we, we're hearing about all the time, additional outdoor seating, gazebos, previously not approved. The agenda item presented to the P&Z Commission for approval read instead to add shipping containers, etc., and the small restaurant will remain as is. Based on that representation, the P&Z Commission has approved the application with the sole condition of rectifying previous violations, not taking into account the significant change of use that the pub would create. The change from non-cooking sandwich style open deli hours to a pub to serve pizza, alcohol, live music. I think most of us love pizza, live music, alcohol, beer, wine. But, we don't feel our little residential area neighborhood is designed for it, and that's the proper place for it. Anyways, let's see, what else do I got here? Yes, just the general incompatibility of the existing neighborhood, as well as the overall health and safety of the community required by the provisions of Village Code Article 2, Section 1845. We don't think we're given proper consideration of this. That intersection at Meadowlark Lane and Corrales Road, everyone is familiar with that. It's a dangerous intersection. And DOT does not allow any more ingress or egress, right, on Corrales Road. But the village or P&Z doesn't seem to have a problem moving that 50 yards down the road to Meadowlark, which is good if all feed into Corrales Road and get backed up at times during really busy hours, if the hours would be from 11 to 9 or whatever. So that's our problem. So we respectfully, want you to we accept our appeal. That's all I've got.
Any other appellants would like to speak? You got 4 minutes.
My concern is the north, oh, I'm sorry, Mary Ann Mieta, 116 East Meadowlark Lane. I swear to tell the truth.
And nothing but the truth.
And nothing. I think I lost all my time. Our concern is light, like cars coming out. And the wall that was put up is not really a wall, it's a fence with slats in. And that's not going to prevent light coming through. And it certainly is not going to prevent sound coming through. So just things like this that, if we want to work in good faith, let's work in good faith. And let's do what needs to be done. We're not trying to hold Mr. Hobbs back from making money. He bought that property. We just want this all to stay conducive to a residential neighborhood. And right now, I got to be honest, I talk to friends around the city and I tell them we have a liquor license on our street and they don't believe it. I said, I guess you'll have to come and see for yourself. Thanks.
Any other appellants would like to speak? Speak now or forever hold your peace. Okay, good. Mr. Hobbs, you have 15 minutes.
Hey, Mr. Mayor. Good numbers. I gotta admit, there's a lot to unpack here. My name is Robert Hobbs, 222 Andrews Lane, Corrales, New Mexico. I swear to tell. I do, yes. Sorry. Do I need to redo that?
No.
Okay, I swear to tell the truth. Like I was saying, there's a lot to unpack here. I listened to Rudy talk. I've sat in Rudy's living room, as a matter of fact, not too long ago, and we discussed. Rudy stated some things that really struck me as a bit offensive, to be quite honest with you. When he didn't receive the outcome that he wanted, it was because you all were neglectful. The planning and zoning was neglectful. I remember the very first meeting with the planning and zoning back in 2023 was approved. They appealed. We met with the council again. Mr. Alsobrook was here, and one other council was here. It was approved again, and that met with actually a physically accosting of one of the council members coming out the door. And I can't let that go because it just goes to the whole thought in my head that just keeps turning over and over again. When they don't get the result they like, they blame you, the council, they blame planning and zoning, they blame everything else. I understand there were some procedural issues here with the certified letters, but let's all be honest, everybody knew about this all the appellants, all the people in opposition knew about this. I knew about this. I've been waiting for this appeal for some time, to be honest with you. And when I thought that it was going to be delayed again, my heart sunk. I just want to get this over with. I want to conduct my business in a commercial zone. You all took a look at a photograph of our building and how it sits directly on Corrales Road across the street from the Village Mercantile, from the little mini mart, the Frontier Market, from the massage parlor, from the gas station. They are all closer than most of these people's houses. I think the Ritters have more of an argument than anything. And all they had to complain about was the construction of the wall. We haven't even opened yet, and already there's a debate about alcohol and a pub and drunkenness and drunk driving. I've done so much research. I talked to the police about the POLD, place of last drink. Most of the people that are caught for drunk driving are coming from Albuquerque trying to sneak up into Rio Rancho. They're driving up on the ditch. We have liquor licenses at the two places I mentioned, the gas station, Frontier Mart. We have a liquor license at the what is it called? The little coffee shop down the road. They serve wine down there. The farm stand, my goodness, 4940. And the Indigo Crow. I mean, longstanding institutions in this village. And Perea's Bar, my goodness. Somebody talked about Perea's, and Johnny's a good friend of mine. And I just don't see how bringing up a liquor license is going to bolster any sort of argument that there's going to be drunk driving. We're not out to create a pub that people are going to be boisterous and loud. I read the emails that go around in this village, and I was called out in one of these emails for being a rock drummer. I haven't played in a rock band since the 80s. I'm a jazz and country drummer now by trade, and as a matter of fact, I'm not even a drummer anymore because I'm getting old. I'm 63 years old. I want to retire. I live in the neighborhood. I drive on the same road. I've talked to all the other neighbors up and down Meadowlark. 99% of them are in favor of this. The ones that aren't just say, you can do what you want with your property. You know, one of them had a concern initially about traffic, and she said, I was pleasantly surprised to see that you didn't create any traffic because you had a no left turn. Everybody has to go right out of my parking lot. The fence I built was one of the conditions. I thought it was a fine fence. Now all of a sudden it's a problem. When I'm trying to, we tried to make it a nicer place. I poured a little concrete patio. That was my bad. I did that without Brian's permission, but now I'm here to pay for that because there were people sitting on picnic tables in that very same area outside of Bell's Deli. There was never a promise of no cooking. As a matter of fact, I would go into my building and Bell's was cooking garlic. They baked bread. They cooked short rib sandwiches in there. There was a lot of cooking going on in there. I never promised no cooking. And I never promised anybody anything specifically that I'm violating. They talk about truth. I want to be honest here because I don't want to get caught in some sort of lie or some sort of mistruth. But the mischaracterizations and the misrepresentations of things have been just unbelievable. I've had to sit back there and endure somebody telling me I have absolutely no empathy at all whatsoever. And that hurts. It really does. And I'm not trying to sound like a crybaby here, but when somebody is telling you you have no empathy, you're dishonest, you're going to do these things, even though we haven't had the opportunity to do them yet, I plan on running a very respectful and very small restaurant that happens to serve beer and wine. Quite frankly, I like a beer with my pizza, not 10, a beer. Some people like a glass of wine with their asparagus sandwich or whatever it is they're going to have. That's what we want to do. We want it to be nice and quiet. We're not going to have big outdoor parties with loud music. I can assure you of that. I will abide by every single ordinance, whether it's lighting, noise, parking, whatever. There are pictures in there of a delivery truck. One guy, some knucklehead from Shamrock, parked on the road. But the last I checked, there is nothing wrong or illegal with that. Right behind where he parked, every Tuesday at the next door neighbor's house, a lawn care company parks and they block my driveway sometimes. I don't call the police. I don't take pictures of it. I go up and ask the guy if he can back up so I can pull into my driveway. That's it. We've had construction vehicles parked across the street. We got loud barking dogs. Never once have I ever thought to take pictures, recordings, or complain about it. That's what a good neighbor does. You know, if you've got an issue, you talk to your neighbors. I tried to reach out, and nobody wants to talk to me except Rudy. I got to give him credit for that. He had me in his living room and we spoke, and it was a nice conversation. I think we still don't see eye to eye on this, but I haven't even been given a chance. I think that I live in a commercial zone. Look at where we are. Look at the gas station, look at Frontier Mart, look at that intersection. On one hand, they call it a quiet and tranquil neighborhood, rural neighborhood. On the other hand, they're complaining about the traffic. That isn't my fault. These cars are going up and down Corrales Road every day. I can put more Latias on that if that's what I need to block lights. I'm happy doing that. But at the same time, I'm looking at that house on my ring cameras every night with floodlights blaring into my property. I mean, let's just, if we're going to be honest, let's all be honest about everything. Let's be forthcoming. Let's do what we say we're going to do. And then just have peace, please. That's all I ask. Shipping containers were moved because I was in violation. They were too close to the border. That's what the site development plan is really about. I moved them 30 feet away from that wall. Like I said, I poured that concrete because it was dusty and dirty where people were sitting on picnic benches. And I put up a couple of gazebos because I could put a shade sail at the top of them and give people shade if they want to sit out there. I haven't built a stage. I haven't put up any lights. Every time somebody says I'm out of compliance with a lighting disorder, I go adjust my lights. And that was once. And I did it. And I'm in compliance. And I respectfully ask this committee for the chance to do business. And if I violate any ordinances or I become a big pain in the neck, come get me. Because I promise you, I'm not going to do that. I'm a good neighbor. I really believe that. I help my neighbors when I can. I put my money where my mouth is. I walk the walk. I build fences. I do whatever my neighbors ask of me. I help out. And I do have a lot of support, I got to tell you. Neighbors up and down the road. I can tell you they support me. You can believe me or not, but they do. I promise you that. I'm rambling now, so I'm going to leave you be. The reason we don't have a lot of supporters here to come up and speak is because this is the 5th time that I've had to come here and do this. And I can see how glazed over y'all get when you sit and listen to all these people come and say the same thing over and over and over again. So I respectfully ask for your approval on this. Let me try to do my thing. Let me be a good steward, and I won't disappoint you. Thank you.
Thank you. Are there any questions for the appellants or appellees? Yes, Councilor Murray.
Thank you. So, this is for Lori. There was a mention in the minutes by Mr. McClernand that the driveway was in violation because there were 2 driveways. There was the one off of Meadowlark Lane, and then there was one that came off the northern part of the property to Corrales Road. Is my understanding that that northern portion will be closed off?
Correct. That's my understanding as well. I will tell you that during the planning and zoning hearing, there was discussion. The fire chief was there. He would like to run a fire line, so he would like there to be a gate on the north side. I suggested that the applicant perhaps talk to NMDOT about allowing perhaps employee parking only to come in and out of that way, which would actually lower the amount of traffic on Meadowlark. I don't know if NMDOT will approve that, but it would help with the neighbor situation of everybody coming in now.
Is that opening in DOT right away, or is that the private driveway?
The private driveway is on Mr. Hobbs' property and serves ostensibly his property. What happened, NMDOT did not allow Meadowlark's driveway to be closed off entirely and that be the one and only business entrance. That was discussed in 2023.
Okay, so our ordinances stipulate that the driveway entrance to a commercial entity has to be 28 feet.
Correct. And that was brought up during the planning and zoning hearing in April. And again, we talked about it, and Chief Martinez said, from his viewpoint, he's perfectly fine with a slightly wider opening. There is also a dumpster enclosure that you really can't put behind a wall, that has to be serviced. So if you take that out of the equation, I don't know how many feet are left, but correct, the area in the front is about
Yes,
50.
but the point is, the fire chief's conditions and our ordinances for the site development plan are two separate issues. Therefore, the applicant needs to apply for a variance if he wants that driveway wider than 28 feet.
Planning and Zoning Commission did not require that. That's all.
No, that's a requirement. That is a requirement. 28 feet is a fixed ordinance in our ordinances. It is a fixed width. There's no deviation. Therefore, he has to apply for a variance for that.
Respectfully, Counselor, I can think of so many. My gosh, the gas station.
Well, then,
all there's all the. I understand where you're coming from. I do
But
understand.
it's still-
It was discussed.
yeah, you may have discussed it, but you did not have a final assessment of that. So it's my opinion that he needs to apply for a variance if he wants a 50-foot opening there.
Understood.
Okay, so there's also, Mr. McLaren also pointed out that the drawing that was showing the parking was nonsensical, which I agree, because I didn't understand the parking over by the Metal Arc side. I think that needs to be corrected. That needs to be a true, accurate reading.
We didn't find any deficiencies. They would have to be
Geez, come on.
defined.
Lori, let me pull it
There
up.
are 9 by 20 parking spaces. There's an ADA parking space. It didn't change from what was heard in
I'm
2023.
looking at the drawing right now, and on the it's lots 13 through 20. You have 24 feet, then also 5 feet, and then 72 feet. What the hell is that? I mean, it's the accuracy of the site development plan needs to be presented to Planning and Zoning Commission. It just doesn't make sense. And I think Mr. McLaren has a good point that those drawings need to be accurate and they have accurate measurements.
Counselors in general, I would ask that you look at the document I gave you that is labeled 2026 amendment additions noted or highlighted.
Which one is that?
It says AS
Well, that's the one I'm
101,
looking
and
at.
I wrote in red Sharpie
Yeah, that's
2026.
the one I'm looking at, and I think that is what Mr. McLaren brought up. Those measurements just don't make any sense.
I don't see any deficiencies with the same parking lot that's been there for 3
Yeah.
years.
Also, for Mr. Hobbs, this goes to the shipping containers. Our ordinances in 1837, I think it's I-2, stipulate 4 types of materials. That is stucco, adobe.
Wood, yeah.
No, not wood. Wood's never mentioned. We only have 4 types. And I think, let me bring this up. It is materials, stucco, adobe, slump block, and stone are allowed, including stucco. Materials such as aluminum siding, metal wells, mirrored glass, unstuccoed masonry units, and concrete are not allowed. Wood is never mentioned. Therefore, the 4 units that are materials that are mentioned, you need to either cover your shipping containers in one of those 4 materials or take them out and put up something that's usable for you that meets the ordinance under 1837 I-2 or I-1. I have probably a whole list of conditions that I think that need to be addressed. I will concede the traffic study is going on right now for Growlis Road. The Metal Arc intersection is being considered by NMDOT. A traffic study is a required feature of one of our ordinances, but I'm not going to require that because I think the DOT will answer that question for us probably in shorter order in a few months. I think also general compatibility. That's another issue that I have a concern about. Is that and you also talk about fencing. So when you move the shipping containers, what's the fence line on the eastern portion of that property?
Oh, it's the same wall that's been there the entire time. It's a 6 foot high frame stucco wall. It hasn't changed.
On the eastern portion of the property then?
Pardon?
On the eastern portion?
Yeah, northeastern, yeah.
Okay, and you've put up a portion of looks like a coyote fence,
Oh, what?
a coyote fence or
Latia.
yeah, Latia fence, but are you going to extend that on down to Corrales Road?
No.
Why not?
I was asked not to do that because it's too high and the line of sight there would be a problem.
How much line of sight does he need? Lauren?
Yeah.
Okay. So in the first hearing, when the uses were discussed for this building, we did talk about the buffer fencing on the south side. And we noticed that, there's a sharp curve or sharp corner there rather.
Yes.
So the reason for the buffer fencing is to shield from the houses across the street. But we did not want, I've walked the site. It was my responsibility given to me by the Planning and Zoning Commission to walk the site. I have actually asked recently that it be a little bit extended, but we don't want a 6-foot fence where you're pulling up and need to look down north on Corrales Road to see who's coming. So it does end prior to that corner.
Well, I think in previous places like over on Loma Larga, I think we have kind of allowed the fence to kind of let's say angle so that it gives a open line of sight, but it also provides privacy. Isn't that right?
Correct. I will also point out when you look at our ordinance that has to do with the site triangle, it says 25 feet and 25 feet.
Okay.
But then it says if there's special circumstances, we may take those into account, and that's what we did here.
Okay. Is he going to replace the fence on the Corrales Road?
Yes, I plan on doing that with the same type of fence. Have you seen the fence on Meadowlark that I built recently? It's about 4 rails. It's very similar to the one in the photograph that has the 3650 on it.
Yeah, you need to be tomorrow.
I'm like way too federal. If you look at the photograph in there, there is a picture of a fence. It has the address 3650 Corrales Road on it. And that is the type of fence that I kind of wanted to continue around. With some openings, I put boulders in there that, so you just can't drive through it.
Yeah.
But just to make it a little bit more interesting, the tenants in my building, I had a high fence. I had a 6-foot high wooden fence that was 25 years old, blew over. And that's what happened with this driveway that's on Corrales Road. The fence all blew over. I had it all torn down. It was just falling apart. The tenants were so happy because now they have vision. Desert Bird, Mercantile, and the yoga studio have signs above their doors, and they like the visibility that, you have from the gas station, from driving down Corrales Road. So I put a lower fence, which I think is okay, in terms of code. I don't think that I have to have a 6-foot fence.
No, I think according to our fence code, isn't it 4 feet?
Yeah, 4 feet and 40% fill
Yeah.
above 4 feet.
So, yeah.
So yeah, I exceed that with the rail fence that I have.
Okay. So let me ask you this, because it seems to me that you're bringing in a new restaurant, which is a lot different from what the delicatessen was there. And therefore, it's now a new restaurant and a bar use, whereas the delicatessen was just strictly a small restaurant or a small deli. It seems to me that this should triggered a use by review for the Planning and Zoning Commission. Why wasn't?
Sorry, and Mayor and members of council, this actually, I'm finally prepared. It took a little while to dig into the history of this because it was so long ago now. But to the mayor's question earlier, which was delicatessen restaurant, what is it? What was approved? And then how do we define those things? So it was actually use by review back in 2023. And that was originally July 19, 2023, where the proposed uses that were listed were a restaurant with alcohol service, various office/retail, and a yoga studio. And so that was the use proposed at the time. So it was a use by review that actually triggered that site development plan initially. And so the use that was approved at that time was a restaurant with alcohol service. And so there is no change in restaurant to restaurant under village code because the only thing in the code under 1837 subsection D was where I was looking. That use by
Yes.
review is where it specifies a restaurant is a use by review. And so that use was reviewed by P and Z and was approved and then affirmed by this council back then. And so that was pulled straight from the minutes. Sorry, let me get back to it again. Include a restaurant with alcohol service, various office/retail, and a yoga studio. That was what was approved during that P and Z meeting.
Yes, there was, and it was on the public notice sign,
Uh,
and it
I-
raised a
I-
lot of eyebrows.
I don't think there was alcohol at the delicatessen.
No, they chose not to.
Okay,
They had a liquor license at 2 of their locations up in Rio Rancho. They chose not to bring it down into Corrales. I didn't ask them why. They didn't do too well. They were busy for a while and then they just kind of fell off. But they had a beer and wine license there that was put on the public notice back in 2023. We did revisit this at this amendment on April 15th, and we did discuss the restaurant. And it was approved by the Planning and Zoning Commission at that time, not that long ago. That's what's triggered this appeal. But it was no secret that, you know, I was going to cook pizza in there. But make no mistake, Bell's Deli was, they call it an urban deli. It was not a deli by any stretch of the imagination. I think they liked the name because it sounded really neato and cool, but it was not. They cooked
Well,
in there.
from what I remember, and I went down and purchased product from them. It's a small kitchen. I mean, they barely had room to turn around in there. Are you proposing expansion
Nope.
with the pizza oven?
Nope, it's still a small kitchen, same size as it was. Hasn't changed a bit.
And you're proposing to serve 50 people out of that small kitchen?
I am.
If you ever go look at the Village Pizza, you see how big their kitchen is?
Well, they have a massive place too.
I know.
They have a lot of seating. They seat a lot more than 50 people.
I
can tell you.
understand, but that kitchen concerns me that, anyway, that's.
We have our environmental health certificate. They passed it. They came in, they looked at our kitchen, approved it.
Okay.
We're good. And I do believe that we can work out of there.
All right. Lori, let me ask you this. Was a general compatibility of the neighborhood ever conducted for this application?
Those are esoteric discussions that take place during the Planning and Zoning Commission. So there is something I would like to say to address that.
Okay.
So in 2026, 2 months ago, the already approved uses within this building, retail, office, and restaurant, were not re-adjudicated. The space devoted to former Bell's Deli will now be Gale Road. And obviously council approved a liquor license recently. So the commission did and does ask what's changing. They asked about new hours of operation. We've talked about the fire lane for a while, the north side, parking access, et cetera, occupancy of the restaurant portion, and other topics. But this is the Planning and Zoning Commission. They did not relitigate the use of a portion of the applicant's building as restaurant space. But they did ask those questions. They asked about music and et cetera. That's where the compatibility. It's a public hearing. What are you going to do now that's different than Bell's Deli was doing? And after hearing the applicant testify, they chose to approve it.
Okay, so based on we have a noise ordinance. It basically says no amplified music right now. That is the ordinance that is on books. Does this mean that there will be no amplified music coming from this facility outside?
I will let the applicant answer that question. I don't want to hearsay testimony.
As I've said, I will abide by all ordinances. If that's the ordinance, I will abide by it. If the ordinance is a 6-foot fence all the way to the corner, I'll abide by it.
Okay.
I don't wish to be in violation of any ordinances. I really don't. And I don't mean to sound jumpy about that, but I really don't. And here's the thing. I don't know where this idea of amplified music came from.
Ordinance.
No, at my place. I don't know where that came
Well,
from.
I think it came from the gazebo, the possibility of a gazebo. And also
the gazebo are 4x4s connected.
I mean,
in a 7x10
but we have other restaurants that have a gazebo. Have outdoor amplification, and there's issues, but that's why I'm asking you, are you planning on having amplified music?
Respectfully, no.
Okay.
No amplified music outdoors. The gazebos are merely another way to give shade. I've got a few umbrellas as well, but these are kind of cool. You can set a table up underneath them and then put a shade sail.
Yes, but it concerns me about with liquor license, it's strictly restricted to your patio and the restaurant itself. It's not the gazebo. Is that correct?
Well, the gazebos are on the patio.
From what I saw on the plan, it looked like to me the gazebo was set outside the patio area.
No, there's an outdoor patio where we need shade because the sun, I mean, it's got south facing sun there all day long. And like I said, people were sitting at picnic tables out there in the dirt before. I poured concrete, made a little patio in that small area. And then I put up these little 4x4, it's a kit I bought from Vivor. And you connect them together and I made them basically 7 feet by 10 feet, I think. Enough room to put a table and 4 chairs underneath.
I'm looking at the drawing that's marked 2026, I think Laura provided. It's marked and highlighted in yellow. It appears not to be attached to the building.
No, they're not. They're freestanding.
But
Just like a
my
table.
understanding is that the liquor license is only concerned with the interior of the building.
And the covered patio.
Yeah.
Yeah.
But this area that is south of the main building, it is excluded from the liquor.
Yes.
Okay. Just want to make
Yeah,
that.
we don't have from the ABC board. We don't have that.
Okay, very good. I just wanted to clarify that. Mayor, I will advocate my use of the floor right now.
Any other questions to Mr. Hobbs or the appellant? Councilor Muir.
Mr. Mayor, I don't know if I have a question yet for Mr. Hobbs, but I'll just start out with the fact that Mr. Mieta started out with saying this place has been fraught with confusion and well, that may or may not be true. It's the use of the words that really get my attention is on page 2. And this is coming from people that are the appellants. They talk about a source of mitigation. And would that be P&Z's responsibility, that mitigation that they make reference to there? Or was that your wording there, Mr. Mieta, with regards to what we're asking for here? On your, because it's on your, look at your own page 2.
We're talking about the other side of page.
No, the original. No, only 2, I can read it.
Submitted April 8th at the top.
That's I'm all.
This May 4th.
Are you referring to the letter
Yeah.
from the appellants?
Under argument, right. Above argument, right after start of page 2. Assurance of mitigation above objections was not adequately presented or considered. You don't have to necessarily, that's what I see, you don't necessarily have to answer that one. Really going to PMZ. Do you want to make reference to that, Mr. Mieta?
No, because I'm not quite sure.
Mayor and members of council, I was present at that hearing, so I can at least illuminate a little bit of what was discussed.
Great. Where I'm going, I think you understand really where I'm going. Have we tried the mitigation? Because we're getting to the place where we're going either this or either that. I'm more of the mitigation, and I'll get to that point in a second.
Understood, and thank you. So what was discussed and considered by the members of the commission was many of the same things that have been brought up. Potential violations of having, lights facing outward as opposed to downward. The possible headlight sweeps into the neighborhood. More traffic onto Meadowlark whenever people are coming in and out of that driveway. And so all of those things were discussed. A lot of those things were also the subject back in 2023, where actually the applicant had gone to NMDOT and tried really hard to get access onto Corrales Road as the main egress and ingress to the business. and was denied because that's NMDOT.
And
But
I'll come back to that.
sure, but all of those things were things that were discussed and considered. The appellee did discuss a lot of the things that had been done so far and some future intentions, such as, you know, expressing the willingness to extend the fence beyond, or to you know, to add to those things that may have had gaps, such as the slats, you know, the wooden slats. You know, if lights are still shining through, he was made aware of it, I believe, at that hearing for the very first time. And so there is definitely a willingness on his side to mitigate, at least from what I understood. That said, one of the original conditions of the a very first permit, which again is not really what we're here for today, but is relevant, is that one of the conditions was that right turn only sign that the commission and the council both imposed, as well as ensuring that that fence between the neighborhood and the business was constructed and was sufficient to help buffer. And so, yes, mitigation efforts have been put in place, and it would not be inappropriate if council feels after hearing testimony that there are other things that still need to be done to help maintain a, you know, a good relationship with the neighborhood. I think that generally is sort of the most preferable approach to that kind of thing.
Thank you for that. Thank you for that. And that's kind of where I'm going, and I'm going to stay on that for just a little bit of time because of the fact that we've heard situations where DOT is not compatible, but we have a new administration coming in. We have a new DOT secretary coming in, and we're still dealing with the secretary that we even have now, making some progress along the way. But the fact that you only have a right-hand turn coming out of the business, you wanted to go left, but you can only make a right-hand turn. That's pretty much where you're left. So you're going to go down the road a little bit, make a left-hand turn, so you can come back and go down south like you really wanted to go in the first place, because the only place you could go was a right-hand turn.
No, the right-hand turn is just out of his parking lot onto Meadowlark, not off of Meadowlark onto Corrales Road.
Meadowlark, you're going to be able to make a left-hand turn.
Onto Meadowlark from my lot, no.
Case, yeah.
But anybody else who comes into that parking lot, coming out onto Meadowlark, must turn right and head toward, Corrales Road only. In other words, you can't just go cruising down Meadowlark.
Yeah.
You know, and make traffic down that way.
Exactly. And I'm with you, but I'm more concerned about Corrales Road, as you know, we're making some progress little by little. And it was mentioned earlier that we still have a ways to go. And I'm more worried about right now about to be able to mitigate some of these kind of situations ahead of time, saying, so when we get to this point, say, well, we talked about this and we had some agreements where we want to protect the neighborhood as much as possible. And so therefore we work together, and not just you versus DOT or them versus VOT, but you're working together on this particular issue as to exactly where it's going now that we're going to have a new traffic study, things of that nature are going there. I just would like to be able to know if there's some history, or if there's somewhere along the way, as you said, we can make some amendments or some suggestions as to exactly how we can proceed with this, if we proceed with this, to have some mitigation and having workings with one another, as opposed to, okay, you won, I won, you lost, you won, and it's over with, because I don't think it's going to be over with by any means in the near future, even within the next 6 to 8 months.
Yes, sir. Yes, sir. You mentioned history. I will give a really quick history of this building. I've only owned it since 2019. I bought it back then. I'm a therapist, physical therapist, occupational therapy, speech therapy took place in my building. Adults with developmental disabilities, the entire thing. Before that, it was I guess you would call it a preschool daycare center. Darling Tribes from the year 2000, essentially on. For the better part of 20 years, that was a daycare center. And there was a lot of traffic going in and out of there. You talk about a wide driveway. The driveway was, I would say, well over 100, 150 feet at that time. When Darling Tribes was there for the 20 years, there were a lot of cars going in and out of there. They had a lot of kids. They took care of a lot of kids. They had a lot of employees. There were no complaints about traffic then. When I opened up my clinic there for adults with developmental disabilities, I combined 2 other facilities from Albuquerque and Corrales into one. I had buses coming in and out from 7 in the morning until probably 4:30 in the afternoon. All my employees parked on the road because we thought that was okay. They park just to the west of where the fence is, where the buffer fence is that I built. I never heard a single complaint about that. The buses going in and out, I had to hire 2 guys and put yellow vests on them and put cones out there to direct traffic because it was so bad in the morning, and just all day long, buses in and out. And that's the nature of the business, because we worked with adults with disabilities, a lot of people in wheelchairs, a lot of people that are not ambulatory. They have to take large buses, large vans, things like that. So this building and Meadowlark, East Meadowlark, from Corrales Road, I'm the first left into off of Corrales Road, has a long history of traffic, and people coming in and out. So this is really nothing new. I'm going to have a small restaurant, and I guess I hope that I have 50 people there at one time, but part of me hopes I don't, because it's a small kitchen, it's a small place, and I've never run a restaurant before. But if I do have 50 people out there, there at one time, I'm going to deal with it. I'm not going to violate any parking ordinances. I'm going to have ample parking. And I'm not really sure what the discussion about the parking spaces are, but I'd be happy to clarify that. It's the same one from 2023. Joe Brawley, the architect who designed the building originally, did the site development plan in 2023 and did this amendment in 2026. And the parking lot, the only thing about the parking that's changed is he put a couple of employee spots back on the other side of the building in the back. That's the only thing about parking that's really changed. So I understand your concerns. I hate that intersection because it's such an acute right-hand turn off of Meadowlark coming to here. It's ridiculous. And if you want to go to Albuquerque from Meadowlark, you actually have to turn as if you're going to go to Corrales so that you can see the cars coming. Otherwise, if you're sitting there, you're straining your neck to look out your back window. It's a horrible intersection. You and I talked about this after the last meeting, and I'm really hopeful that you can pull off in the traffic circle or something there to mitigate the traffic on Corrales Road, because there's a lot of traffic on Corrales Road, but there's really nothing that I can do about the traffic on Corrales Road. I can do my best parking, but that's
Mr. Mieta or anybody else over there, do you have anything to say about ability to see if we could work together on some of these issues, as opposed to putting it down in black and white and leaving it at that?
I like the idea of moving towards mitigating things and working things out and so on. And I respect and I understand your spirit there. I don't want to speak for Deborah because she can speak well for herself, but some talk came up about maybe having a better fence that actually does block out headlights, okay? Because when Darling Tribes was there, nobody was there after 4:30, as you admitted, so that was never a problem then. The other thing is the sound. So if there was a better fence, that could, there's even a cliche about fences make good neighbors or whatever. I'm gonna yield my time to Deborah and she can express.
Please do.
I'm Deborah De La Torre once again, and I do live right across the street. And I can tell you that noise really travels around here. When the deli was there, I could hear dishes clanking in the kitchen. I could hear all the conversations. I could hear all the noise in the parking lot, the patrons hanging around. There's a lot of noise. The fence that Mr. Hobbs was required, it was a condition at Planning and Zoning back in 2023. I didn't mention it because I thought we weren't supposed to bring up 2023, but that was a condition of him getting approval to put up a fence that would block light and block sound. And he put up a see-through fence, which is a Latia fence. It does nothing for sound. I hear everything that goes on in that parking lot. All the doors opening and closing, the car doors, everything. Like I said, I hear them in the kitchen. Noise travels here. And it does nothing for lights. You can see through, it's a see-through fence. It's a Latia fence. And besides that, where the opening is, I don't know why people still back in. But when Bell's Deli was there, people would back in, unload things from their trunk with their headlights on, the car's idling for 20, 30 minutes while I'm taking care of my horses. The whole time, I'm doing this because I have headlights shining on me and my horses while while I'm trying to do my evening feeding, especially in the wintertime, because, it's dark earlier. And they would sit in the cars, just idle there and hang out with lights just shining on me. So it's been very unpleasant. And I'd like you all to come over and visit me and see what I'm talking about. So I thank you for your consideration. It feels nice to be heard. I appreciate you all. Thank you.
Thank you. Back to the council speakers anyway. On some of these issues, I felt that there was enough that they put them in their initial complaint that they talked about, that there was, had we really taken a good look at what's good for the neighborhood and concerns. So do you feel that there is something that we could do here to have these individuals work together on some of these particular issues and not just necessarily have a yes or no vote on this particular as it stands?
Mayor and members of council, so yes and no. The right answer is that it is up to council to impose some conditions if they feel that that's appropriate. Given the circumstance, which is that it may be that a different style of fence is in order, it may be that some things like that are things that could be conditions. The only reason that I'm not just giving you a yeah, absolutely, let's do that, is that one, that may create some impositions with respect to driveway requirements, egress, ingress requirements. It also may violate code in other ways, depending on what is considered the front lot line of this lot, because there are some requirements to have a see-through fence in order to be able to not obstruct the clear set triangle. So there are some things that would need to be considered before we could give like a concise recommendation as to what that solution would look like. But understanding that council can, I mean, not unlike what we did back then, which was to say that we put it on the applicant to work with DOT to see if there was even any way that he could get access off of Corrales Road. And he did that. And so I think that that would be a reasonable kind of condition to say, it is the burden of the applicant to figure out what the best kind of fencing he could construct to be the least impactful to his neighbors and still comply with code. I would hesitate to go so far as to require him to request a variance, because that's also a very burdensome process, but there has got to be a middle ground of some kind. Because of those height restrictions, once we're over 3 feet, it has to be see-through in a certain part of the property boundaries and so on and so forth. So with some considerations, yes, I think that we could put forth a reasonable condition that would allow the neighbors and the property owner to, come together with a solution that would be maybe not the best for both of them, but livable for both.
Well, I would prefer that in the way in which you did, especially because in the near future, something's going to be happening up and on that corner, and this will help prepare for that one. But it also would be that just because DOT says this, I'm not one of those, and I've never had all my successes and been. Let's sit down and let's work on it and let's talk about it. And we usually wind out winning when you sit down and talk. And so I'm afraid that if we just leave it as it is, and we walk away from it and say, okay, you lost, you won, I get. It doesn't help the community at all. And the people that live in that particular area. So would like to be able to continue to push, and I mean the word push, DOT, because I don't find any reason why they should not want to be able to have access to a business that's coming along in their area. Did you want to say please?
So the see-through fence, the Latia fence, it's just sticks. So it doesn't do anything for sound or for light. It kind of buffers light a little bit, does nothing for sound. A big, thick adobe wall would be wonderful, 6 feet high if that's possible. But the fence that affects me and my horses is not close to Corrales Road. I understand we have to be able to see Corrales Road. I'm not concerned with the fencing that goes beyond. Well, my neighbors would be concerned. There's new owners there, but to the corner of Corrales Road and Meadowlark, that could be open or the low fence. the Latia fence that should be like an adobe wall or a block wall that might muffle sound somewhat because noise and sound really travels here, but it would at least block the light. There's going to be a problem where my fence is directly across from him. So where he has to have a driveway to go in, I'm probably going to have to put up something to shield the lights next winter from my horses because he's got to get in and out of his driveway, right? So the Latia fence could be replaced with something solid, and that would certainly help with sound and with light. So, but it's not up by Corrales Road. That should be open so that we all have visibility because we all know what a dangerous corner that is. So, thank you.
Thank you.
I'll
turn it over to.
I have a question. I haven't asked a question lately. Go ahead.
I'm
You
sorry.
can be.
Just
Go ahead.
a quick question about your conversation with DOT. In the material we received, it said basically they said no. What was their discussion about it?
My
I mean,
discussion.
there are rights and lefts off of Corrales Road for 6 miles.
I'm glad you brought this up because I did my own survey of Corrales, including this parking lot here is on a hard corner and it has Corrales Road access. You pull right in front of the village offices off of Corrales Road. You don't have to pull in down there. So that's a violation of DOT. There are 18 others in addition to that between here and Old Church Road, including the beloved Wagner Farms with 2 massive gates that they open up on Corrales Road. Sunbelt, I mean, I could go down a list. Even Parea's Bar has. They all sit on hard corners, yet they all have Corrales Road access. I doubt that they all got variances. They have exceedingly wide driveways. And I'm not saying that all of these make it okay for me. But I did bring that up with Miss Towns. Margaret Towns is the name of the lady. And she said, well, you know what we can do? We can put a decel lane from on northbound Corrales Road turning onto eastbound Meadowlark. And I kind of chuckled. I said, please come out and take a look at it because you got about 6 feet to put a deceleration lane. I said, however, you can put a deceleration lane in front of my fence over here. I got probably 12, 13 feet. It's no problem to put a deceleration lane and turn into my Corrales Road property. She stopped talking to me.
What is their objection?
They
Did
just
they ever
said
state-
that's the way it is.
That's the way it is?
That's the way it is. And she respectfully said, you can appeal this decision, which I've tried to get direction from her on how to do, but I never get a call back. I never get an email back, nothing. But I'm trying. And that's why I was so heartened when I was talking to Mr. Miera at the last council meeting, because it sounds like he's making some inroads on better communication and better relations with DOT.
Well,
But I understand.
as we know, that the bottom line is that for years the state has wanted Corrales to take over Corrales Road.
Yes, and
they-
that's
they'll
the
throw up any
leverage.
objection.
Yeah, I get it. But again, I want to remind everybody, when it comes to noise, I want to remind everybody where we are. We're on Corrales Road, right there. Cars, the traffic noise, the traffic from the gas station. Every day I'm out there either cutting the grass or building a table or doing something outside. And I have the life scared out of me by a car that runs over those doggone tank covers. And then the guys who pull up in their cars and leave their music on very loud while they're filling up their cars and their cars are running. So I get it. There's noise there and there's a lot of noise. That is a noisy area and they're less than 50 feet from the building right there. And there's a lot of lights too. And all the headlights coming up and down Corrales. I just wanted to state that because it is a noisy place, which is not to say I can make all the noise I want. I don't plan on doing that. So.
Thank you.
I have a question for Lori and Corey. And after you, Robert. I'm reading from the findings of facts and conclusions of law for the appeal. Number 8 says, the commission stated publicly that STP 2302 was a, quote, big change of use, unquote, confirming that was the purpose of the public hearing. And then number 9 says, based on public comments received, the commission voted unanimously to approve the STP. Those two statements seem incongruous.
I can address the big change of use. So prior to it being approved as retail, office, and restaurant, it was an adult day hab, totally different uses. It was a big change of use. That's what that meant.
Okay. Councilor Paquette.
I think they're only incongruous if you assume that nobody wants the change of use. Like there can still be public opinion supporting a significant change of use. They're only incongruous if that's not the case. And I think we have as many, if not more, letters of support in the packet, just as a general principle. So I think not incongruous.
I guess the question is, where do those letters come from? I mean,
Citizens?
Yeah, citizens in the village, but,
I mean, different ones than are sitting here, but equally important.
well, I mean, I generally, I think the people who live in the area have more standing than people.
There's no preferred classes of people voting on anything in the village. That has already been discussed with our legal counsel. Every citizen has equal standing in this village, regardless of proximity to what's happening.
And Mayor and members of council, just for the sake of clarifying the record, so the item that the mayor is reading from is actually the findings and fact and conclusions of law that were pertaining to 2302, which was the site development plan from back in July of 2023. And so those were the findings from.
So we're asking questions about a site plan 3 years ago?
And again, that's not the item
No,
that's
that's
in front
not.
of
We
us.
need to get this thing back on the rails. So.
Oh, God, I can't stand him.
Mandy,
Yeah.
Mandy, can you mute whoever that is on Zoom?
That will be the future president of my fan club. Tell you what, she's going to have to be vice president now. I hope she's happy with that demotion.
Any other questions or comments by council? Okay,
Vote.
go ahead.
Yes.
I think we need to vote.
I bet I don't.
We've heard,
Are you calling the question?
yes.
Yes.
Well, and there is in motion right now, but I would move that the governing body grant the appeal of SDP 23-02, reverse the April 15, 2026 approval by the Planning and Zoning Commission, and remand the matter back to the Planning and Zoning Commission for further proceeds with the following conditions. And after they have been addressed and approved by the Planning and Zoning Commission, and if there's an appeal by the governing body, but the condition should be that the applicant should obtain a written NMDOT authorization access driveway for the revised plan, or if it comes back and their DOT does not grant that, submit a formal written demonstration that produces Metal Arc Lane will not have any adverse effects. Also, the applicant, number 2, the applicant shall reduce the Metal Arc opening to 28 feet or apply for a variance as stipulated in 1837, I think it is. Also, that also no SDP be approved while the driveway violation persists without an approved variance as well. The applicant, let's see here. Yes, the amended SDP that the Planning and Zoning Commission shall review should also have an express condition, a prohibition on outdoor amplified music or outdoor live music performances. And also the wood burning pizza oven should not violate any express burn bans when it's installed. Also, I want the P&Z administrator to prepare a written report on the comprehensive plan consistent for inclusion in the rehearing. The existing retail space that have a valid business permit should be allowed to continue prior to the rehearing. Also, the Planning and Zoning Administrator shall issue a written determination as to whether wood-clad metal shipping containers satisfy or conflict with the continued ordinance 1837I-1, the prohibition on metal wall panels. If there is a conflict, the applicant should propose an alternate structure design meeting the architecture standards. And then the SDP approved shall, unless the submittal plan should be complete at the time of the hearing. All drawings, including courtyard detail, correct parking exhibit, and so forth, should be. That's my motion.
Is there any second for that motion?
It's lengthy, but I second it, but I don't know how you can chop that one down to.
Well, I think
Well, let's take a vote.
Okay.
Mayor, members of council, just sorry, as a point of order for my own sake. So to be clear, this site development plan amendment pertains only to the placement of 2 shipping containers and the application of some concrete foundation for the building of a gazebo?
no.
Well, not.
I'll tear the gazebo down. I'll drop them up tomorrow.
Counselor,
Anything about the gazebos anymore.
Council, I asked you earlier if there were comments made in the draft minutes were pertaining to this site plan, we could address that as conditions. You said yes.
Yes, and mayor and members of council, the reason that I'm clarifying what's before the council now is that the conditions need to be applicable to that amended site development plan. And so the question I think really that I'm trying to ask here is that the statement about the existing businesses continuing, I want to make it clear on the record that one of the existing uses that was approved and is not being relitigated is a restaurant with alcohol service. So I guess what I'm asking for is clarification in your motion on those conditions to ensure that they are compatible with the application in front of you.
Seems like to me that the conditions I have stipulated are all part of the ordinances within our village.
But it seems to me that we're stripping away rights that were already granted from a previous site development plan, and we're not assessing.
No, I think if we remand this back to planning and zone commission, they have to take a look at this.
Okay, I think you could have stopped the motion then instead of 13 bullet points later,
Well,
because
If there are violations in the 13 points that need to be addressed that the commission did not address.
Yeah.
I understand what you're saying.
Yeah, I just think, you're not remanding it back to them for their opinion. You then are dictating to them what you want to see
Well,
happen.
all they have to do is address the conditions.
Okay. I think I would rather call the vote on this, take a vote, and then we can make a second motion if necessary.
Okay, the vote's been called. Councilor Muir, how do you vote?
Yes, sir.
Councilor Waldman?
Aye.
Councilor Knight? Councilor Murray?
Yes.
Councilor Burkett?
Stunned, no.
So it's 3-2. So motion carries 3-2. Okay. So it's remanded back to planning and zoning with your considerations, with those considerations. So
No.
I guess that's the vote's been taken.
So now we need to decide when findings of fact can be. So the next meeting is next Tuesday. In order to make it onto that agenda, we would need it by Thursday at 5. That's cutting it awfully close. Do we want to shoot for the June 23rd meeting?
Councilor Murray, how much do you feel like writing? I just need the conditions that are in your motion.
I've got
so
it
that I can.
down and you may have to decipher them, but.
Would you email them to me? And
Sure.
then I can meet Thursday if I get Councilor Murray's motion so
I
that we
can
can.
remember between now and then what I said.
Beautiful.
And just to be clear, so we're sending this back to, and then we'll wait for the next appeal and.
Yeah, it goes back to planning and zoning, and they decide what they want to do. And it might or might not get appealed. It's absolutely right. It just goes back to planning and zoning for their consideration. With the specific issues. Yeah. Yes. Okay. Okay.
I mean.
So we have a meeting is going to be next on the ninth. You can do it. Huh? Okay. Meeting's adjourned. Thanks.
Yeah.
Think you have alternative.
Not sure we can save that.
He stepped away. Right now. No, thank you.
You can open it up if you want to.
I don't know if he's gavelled it or what. I guess we're done. Yeah, you call it. Meeting over?
It's not gonna.
No.
Any intro from there?
We need a beer. All right.
Yeah. Like. Oh my gosh.
I do appreciate very much.
Really? Yeah.